Good evening. My name is João Cravinho. I'm the ambassador of the European Union to India, and I would like to begin by offering my very warm greetings to Gujarat National Law University. I'd like to say thank you to Professor Patel for inviting me to be with you in this manner by recorded message, and I hope one day that I will have the opportunity of being with you in person. And also I'd like to congratulate you for the launching of the Academy for the Advanced Issues of International Law. Issues of international law are of the greatest importance for all of us. For the European Union, here we are talking about our genetic constitution. The European Union is 28 states, 28 nation states that have come together over a period of 50 years in successive moments of enlargement, starting with 6 countries, and now as from 2013, we had Croatia joining us to make 28 member states. This means that we have a very particular makeup, because we have done something that is, I think, really an unprecedented experiment in international politics and in international law. We have created a very deep network of processes of integration, mechanisms of integration, through which each of our member states has voluntarily ceded some portion of its sovereignty and yet retains other aspects of its sovereignty. Each of our 28 member states retains, of course, its seat at the United Nations and in many other international bodies, and retains its sovereign decision-making powers in some matters. In other matters, it has ceded those powers to the European Commission and or indeed to the European Council, and we have developed mechanisms of majority voting, for example, which are increasingly wide-ranging. They began some 20 years ago with just a few areas in which it was possible to think of majority voting. Nowadays there are quite a few areas of activity in which the member states of the European Union subject themselves to the possibility of being outvoted by their colleagues. Why do they do that? Because they have confidence that with regard to the great majority of issues, their own interests will be respected and promoted in the best way possible through these mechanisms of integration we have. Now, I'm making these points about the European Union to underline that our very constitution, our very makeup, the way that we are genetically, cannot be thought of without reference to international law. Furthermore, we have actually, through the establishment of new procedures, innovative procedures, we have taken the international law beyond its boundaries into realms that previous generations would never have imagined. Now, having said that, I think create circumstances to understand why, for the European Union, operating internationally means operating internationally through international law. For us, international law is not only desirable, but it is the only conceivable manner in which we can operate internationally as European Union. So our attachment to international law is a very deep one. Some decades ago, 2-3 decades ago, I think we lived through a moment of great optimism with regard to what many believed was the progressive consolidation of international law and the deepening of the acceptance of international law to levels quite unprecedented. I think that, unfortunately, some of that optimism may have been a little misplaced. Nowadays, we find international law not so much evolving, widening its scope, deepening its capacity to determine how states act, how international actors behave. Rather, we find international law fighting something of a rearguard action against multiple challenges to it. And this is deeply worrying. The 1990s were declared as the decade of international law. And in fact, that was a period just after the fall of the Berlin Wall when it was possible to have quite an important level of optimism. It was believed that more and more our behavior would be determined by the parameters that we established under law, and that it would be possible to reach an increasing number of agreements in an increasing number of areas, and thus widening the remit of international law. The International Criminal Court, for example, which was worked on through the 90s, and that came into being in 2002, was, in our view, a very, very important advance that was made in international law. We remain strong supporters of the International Criminal Court, and yet we are conscious that the International Criminal Court has its detractors. The International Criminal Court has some countries and some individuals in some countries who would rather it did not exist, and who do their utmost to render it inoperational. We believe that over time the International Criminal Court will be fully consolidated and its capacity to act will not be constrained. But this is something that requires deep determination and requires a struggle. It's not possible to advance the cause of international law without such determination and without such availability to struggle. Apart from the International Criminal Court, which I think should be considered as a very positive development, we have, however, seen in this past decade challenges to international law that I think many of the optimists of 20, 30 years ago would not have imagined possible. We had, for example, in 2003, the invasion of Iraq, which was clearly illegal under international law. We had, of course, the development of a number of new challenges for which international law is perhaps insufficiently equipped, from global terrorism, for example, to the sheer brazen availability of Russia, most recently with regard to Ukraine, to simply disregard international law and annex a part of another country, to contravene, we're talking of a permanent member of the Security Council of the United Nations, to contravene some of the most basic elements of the Charter of the United Nations. So, whereas some decades ago I would say that there was great optimism as to the future development of international law, today I believe that it is doubly important for those who are committed proponents of international law, of the rule of law in international society, because that is what we speak of when we speak of international law, the rule of law in international society. It is doubly important for all of us to be giving all of our effort, dedicating all of our efforts, in a context in which international law is increasingly challenged. in a context in which aspects of international law are called into question. I think when I spoke in the introduction about our genetic attachment to international law, this may also help to explain why we are so deeply committed to addressing the challenges of global governance through international law. One of the major challenges of our time, one that perhaps we don't see or feel on an average day, but which I think historians and our children and grandchildren will identify as one of the defining moments defining issues of the time in which we live, is the manner in which we tackle, or fail to tackle, unfortunately, climate change. In our view, climate change, of course, there are many different aspects of this topic that must be addressed, affecting different countries in different ways. It is necessary to bring all on board. But ultimately, I believe that we must address the challenge of climate change through science and through international law, through bringing international law into harmony with what science tells us, through creating internationally binding legal agreements that will allow us to bequeath to our children and grandchildren a planet that is worth living in. International law is therefore indispensable for that global governance issue, climate change, but I would argue that it is indispensable for a very wide range of the global governance challenges. International trade, for example, must be governed through international law. In our view, it is most desirable that it should be through a multilateral trading agreement through the World Trade Organization. If this is impossible for whatever reason, if it is decided that the World Trade Organization is incapable of producing new agreements that correspond to the needs of our times, the inevitable result will be the creation of plurilateral agreements, agreements that are not encompassing of all countries, but that bring groups of countries together. Well, that is a second best, but it is a rather dangerous second best. It is a rather dangerous second best because it encourages the fragmentation of the way international law governs a particular issue area, in this case trade. Furthermore, this tendency can be infectious. We may find the development of plurilateral arrangements rather than fully multilateral ones in other issue areas. We may find that instead of international law being increasingly global and all-encompassing, we find instead that it can be increasingly fragmented. I believe that this would be an extremely undesirable development, and one that in the European Union we will do whatever is within our hands, our capacity to avoid. I would like to briefly mention 2 or 3 aspects of international law that we hold particularly dear. The first one, and it should be the first because we must start with human beings, is human rights. We have, since 1948, the Universal Declaration of Human Rights, a wonderful instrument. One question that arises, I think, in the minds of many of us when we look at human rights around the world today, when we look at the approach to human rights around the world today. So the question arises, the way that human rights is increasingly seen around the world, would the Universal Declaration of Human Rights, if presented today or tomorrow to the General Assembly of the United Nations, would it pass? Would it pass with flying colors? Would it be adopted unanimously, as it was back in 1948? Or would there be reservations changes, paragraphs struck down, other paragraphs rewritten, caveats added. I would rather worry that since 1948, our attitude towards human rights may have suffered some sort of degradation. This is the fundamental cornerstone of international law. International law cannot only be the law that governs the relations between states. It must also address humans who, after all, at the end of the day, are what it's all about. And therefore, the Universal Declaration of Human Rights is an essential part of the way that that international law operates. This means, I think, that we must be extremely vigilant and extremely committed to the promotion of all that is in the Universal Declaration of Human Rights. Of course, when we talk of human rights, we do not talk only of civil and political rights. We talk also of economic, social, cultural rights. Certainly, all of these aspects must be taken on board. All of them are important elements. Human rights are, of course, must of course be understood as indivisible. The important point to underline, though, is that it is inadmissible to say that because this or that aspect of human rights is not entirely fulfilled, the human rights, that aspect of human rights has lost its validity. On the contrary, this should only serve as a stimulus to ensure that human rights are entirely, properly, fully respected. That is the position of the European Union, the member states of the European Union, the position adopted by the member states of the European Union as they coordinate their activities in the United Nations Human Rights Council, and as they enter into dialogue, either as EU or individually, with third parties, with other countries. So human rights must be understood as a central plank of European foreign policy. Another fundamental aspect, the first of all human rights, of course, is the right to life. And in this respect, I would greatly encourage the Gujarat National Law University to think about the issue of the death penalty. The death penalty is, in our view, deeply counterproductive. It is, as Victor Hugo, the French 19th century writer, said, there is something deeply contradictory and disturbing about the following notion. The idea that the death penalty is there to teach a lesson. And this lesson, of course, is the simple one that we know through the Bible and through other holy books: thou shalt not kill. So what is the method that is utilized to teach this lesson? The method utilized is killing, the death penalty. That is deeply contradictory. It is deeply contradictory, and it goes against one aspect that in all societies we hold to be sacred, which is human life. And therefore, I think that it would be very important as the world, here I think it is fair to talk of progress, as the world progresses towards a universal moratorium on human rights, on the death penalty. Every 2 years, there is in the United Nations a vote in the General Assembly proposing a moratorium on the death penalty, the use of the death penalty. And every 2 years, the next vote will be due in December 2014, there is an increasing majority of countries, now well over 100, that say yes, it is time that we put a stop to this practice. So I would ask you as participants in the Gujarat National Law University's activities to reflect upon this topic. Women's rights, children's rights are, of course, fundamental components of human rights. All over the world, we come across examples, unfortunately, of abuse of the rights of women, of violence against women, of violence that is engendered by structures in society, or simply by the activities of some people that are prejudicial to women. Even access to education for women, for girls in some places, is questioned. This year, 2014, we had the great pleasure of seeing two very important activists, child activists, rewarded with the Nobel Peace Prize for their work. Malala, of course, the Pakistani schoolgirl, so brave, so courageous, so inspirational, fighting for the rights of children, and particularly the rights of girls to education. And here in India, Kailash Satyarthi, indefatigable campaigner for children's rights, and in particular responsible for transforming the lives of many, many thousands of children who were forced into labor at a very young age, and through his actions have been released from that and returned to where they should be, schools and so on. These people deserve our homage. And I think it is worthwhile reflecting upon how international law can support the extraordinary individual efforts that they and many others make. International law should not be only about, though of course this is of great importance, deciding where a frontier between two countries may lie, or allowing two countries to solve their differences through amicable, peaceful means. These are fundamental tasks of international law. And yet international law has also the responsibility to go further, to venture into areas that are somewhat uncharted. Progress happens when we see that happening. Progress happens when we see an international society that is increasingly illuminated by international law. The opposite, regression, happens when international law is challenged or disregarded. I think that it would be deeply disconcerting in these early years of the 21st century to see the progressive development, not of international law, but of the law of the jungle. We do not have in international society the same kind of ultimate source of authority that single nation states have through their constitution, through their forces of law and order, and so on. We do not have that in international society, and therefore we can only rest upon the conviction that through consent, an increasing number of countries and individuals in an increasing number of areas operate through international law, develop international law, consolidate international law, and make it more meaningful in the daily lives of the 7 billion people in our planet. The European Union does its part. The European Union, for the reasons that I have mentioned, is deeply committed to international law. Here in India, as ambassador to India, one of the responsibilities that I have is to conduct, in partnership with the Indian authorities, an annual dialogue on human rights. The most recent one took place at the end of 2013. Extremely useful exchange of views, quite lengthy exchange of views on human rights issues that affect both Europe and India, exchanging best practices, exchanging ideas, exchanging notions of how each of us can live up to the challenges that we face. I think that this process of dialogue, because we do not have a single international constitution that binds us all, this process of dialogue is the most promising, most significant way of progressing in our aim of having a rule-bound international society. It is disturbing when we see some of the fundamental pillars of international rules, the United Nations Charter, the Universal Declaration of Human Rights, called into question. But I believe that it should ultimately serve, above all, as a stimulus for us who can see the difference between international law and the law of the jungle. Gujarat National Law University, through its focus on international law, I believe can make a very important contribution to the furthering of the consciousness that we all need to have about the importance of international law. And that's why I have great pleasure in wishing the greatest success to the Academy for Advanced International Legal Issues, and to reiterate, as I said at the beginning, that I hope that at some point it may be possible for me to be with you not on a screen, but in person. Thank you very much.